Does a custodial parent's plan to relocate provide grounds to alter a custody arrangement? Arnott v. Arnott considers whether custody should be modified after a parent plans to move several states away. Jeffrey and Paula Arnott lived in Jackson, Wyoming. The couple had 2 daughters during their 9-year marriage. When the Arnotts divorced in 2010, the divorce decree granted Paula primary physical custody and Jeffrey reasonable visitation. According to the decree, Jeffrey would have the girls on alternating Thursdays and weekends, alternating holidays, and 2-week periods during the summer. The divorce decree also required Paula to provide notice if she planned to relocate. By all accounts, both parents were loving and deeply involved in their children's lives, and the children were thriving. In 2011, Paula notified the court that she intended to move from Wyoming to Mechanicsville, Virginia, over 2,000 miles away. After learning of Paula's plans, Jeffrey petitioned for a modification of custody. Under state law, a change of custody proceeded in 2 steps. First, the parent petitioning to modify custody had to demonstrate a material change of circumstances. Second, if the petitioning parent demonstrated changed circumstances, the court would apply the best interests of the child standard to determine whether the custody arrangement should be modified. Jeffrey argued that Paula's relocation was a material change of circumstances. Further, he argued that it was in his children's best interests for him to take over as primary custodial parent. Bound by precedent, the trial court applied a presumption favoring the custodial parent's move. The court presumed that Paula's move didn't constitute a material change of circumstances justifying a modification of custody. Applying the presumption effectively ended Jeffrey's bid to modify custody. The court denied his petition without considering the children's best interests. Paula moved to Virginia with the girls. Jeffrey appealed to the Wyoming Supreme Court.